No, not directly accountable. Other authorities are not directly accountable, but if you see the responsibility of authority in the Act, authority can call anybody. Authority can call municipal commissioner, permission authority, and ask them as to what is happening in this particular case. They have authority, they may not do it, but they have that role to play. If you are not getting permission, first is that you must get permission before registration. If some permission you are not getting, you have to go to corporation only. You can't go every now and then to authority.
I will rephrase this one. If the compliances are delivered without any deficiency, and if there is a delay from the corporation authority for granting the approvals, timely approvals, and subsequently because of that if there is a delay.
My dear friend, in MRTP Act, there
See, your question seems to be very complex. What we could understand is that you have applied to the authority, that is competent authority, that is planning authority under MRTP Act for seeking permission.
Yes.
And that permission is not granted. That is what your case is, or that is what the position?
Not MRTP, civic administration.
Pardon?
Civic administration. I mean the corporation, when we apply for those clearances.
You have approached corporation for seeking certain clearances.
Yes.
Which have not been granted.
Yeah.
So there is a provision under MRTP Act by way of section 47 of appeal, or making application to the state government, or appealing to the corporation, or last resort is go to the High Court, making a complaint that corporation is not granting permission, neither they are raising any requisition, so issue directions to the corporation for consideration of my application. These are the remedies which are available to you under MRTP Act or under other law. There is no question of applicability of RERA unless you register yourself under RERA. So you want to say that you are registered under RERA also, and then you want to invoke the RERA authorities also.
After uploading everything in RERA, for every subsequent stage, we have to keep on applying, right? So if there is no deficiency.
You want to say that you are registered under RERA,
yeah.
You got some permission, and
Yes.
subsequent permission if delayed.
Yes, yes.
What is the remedy?
Yeah.
Okay, so the first answer is already given, that RERA authority can call for the record from any officers, any corporation, and seek an explanation as to why there is delay.
Yeah.
Secondly, let us assume a situation that you have given a time frame for completion of a project.
True.
And that time frame is lapsing.
Yes.
So you have a right to get extension. You can apply for the extension to the RERA and demonstrate that there is no fault on my part in completion of the project. Fault is on the part of authorities who have not granted me the permission, and therefore grant me extension. So for asking, you will get the extension.
Okay.
So there will not be any problem.
Okay.
If permissions are not being granted by the authority, that is altogether a different question which has to be addressed under the provisions of MRTP Act and not before the RERA authority. RERA authority only call for the information. They have no power to give directions to the corporation to sanction the plan. That power can be exercised under writ jurisdiction by the High Court.
Okay. Right. Thank you, sir. Now to the gentleman over here. Sir, I come back to you.
So now, as we are going to register the project in phases, and for each phase then we are going to start executing the agreements. Most of the common areas are going to come in the further phases. Does that mean these common areas are not going to be part of the agreements executed in the initial phases with the people, with the customers? Should they be excluded as part of the agreements?
Whatever phase you define, in that, let's say that you say that I have a swimming pool. If it is not going to come in first phase, don't declare it as the first phase. You can't declare it. Because if it's going to come in second phase, then in the second phase marketing you have to do. See, the idea is what? Whatever you are committing to that first phase customers, that has to be completed by you, then your project is completed. Suppose you are going to do later on some swimming pool, clubhouse, and you don't do it. So what happens? So that's why you can say that this is going to come later on, but your possession, at the time of possession, clubhouse and swimming pool is not going to be ready.
So this information is not only excluded from the marketing, but in the agreement executed at the time, in that also this should be excluded, or in this way every agreement for every phrase will have different things in that way?
See, there is a model form of agreement which is append to the rules. Same was the case with MOFA also. Under MOFA also there was a model agreement form which was append to the rules, and based on that agreement promoters were supposed to execute the agreements. Even under the RERA position is almost same. But if we look to that model agreement and the note which is put up on the head of that particular agreement, then that note gives a clarification that this can be amended suitably vis-a-vis to the nature of your development. Now your question is pertaining to the aspect that there is a phase-wise development. You have registered first phase. There is no occasion for you to register the second phase, but you are executing the agreement. Ultimately, it will be a layout development comprising of several phases. So in my opinion, you should disclose everything in the agreement by bifurcating the things. You have to distinguish the things. For example, you have to state in your agreement that we are launching only a first phase which is registered under RERA. Under that first phase, following things will come. We are also proposing to carry out further construction by phases, phase 2, phase 3, phase 4, whatever. And whatever other amenities which you are proposing to incorporate, you can always say that these are the proposed amenities which will be included in the subsequent phases. So this will be a total disclosure. Even while registering with the RERA, you can make such type of disclosure that today we are registering only first phase 1, but we have a proposal to have phase 2, phase 3, and in phase 2, phase 3 we may propose to have some other additional things also. So what is required is a total disclosure. The basic concept, basic object of RERA is to ensure total transparency, and that total transparency can be ensured only by way of total disclosure about your layout development. So just ensure that total disclosure is made, not specified. You are supposed to specifically disclose only that is which is registered, which is forming part of sanction plan. But there may be something which is not forming part of a sanction plan today, which is not forming part of your present layout or present phase. But still, there has to be a disclosure in my opinion.
Thank you. Now to the gentleman over here.
If I have a running project which is of around 10 buildings, I have completed 3 buildings, I have got the OC. Earlier in my project I have given some disclosure, all my agreements I have given, I am giving a clubhouse, I am giving a swimming pool, it's a 10 building project. Now I register as per my building, as per the phase. If I want one building as one phase, I am going to register it that way. So what about the previous agreements which I have registered, and further what precaution we should take? Because in earlier agreements I have committed a complete layout with my positioning of my garden, clubhouse. I'm not changing anything, but right now if I'm coming to a RERA phase, I'll register as per building. So what precautions should I take? Because earlier my disclosures are different and now it will be different.
See, basically now the format of agreement and the contents of agreement have changed. So all those projects which are ongoing, which are not completed, to which OC is not issued, those will require a registration under RERA. So whatever your earlier agreement format was there, scrap it. Have a separate, independent, different draft.
Which are already registered, because
which are already registered, those will covered under MOFA.
No, but if my project doesn't have the OC, it comes under RERA, as per which I understood. If my project doesn't have the OC, I am governed by the laws of RERA.
Yes.
This is what I understood. The disclosure which I have already made, further I am going to make disclosure as per RERA, I am going to go phase wise, as per building wise, whatever way I feel convenient. But what about my commitments, which, because my layout is already mentioned?
You are already committed under MOFA to those flat purchasers. So whatever changes now you will be proposing, you have to keep in mind your earlier obligations under the earlier agreement, under the earlier enactment. So you can't go by to that.
I don't want to go back but now my agreements are going to change. Now I just make, this is my single building, this is my phase 1 or phase 2 or phase 3. So what precautions should I take? Because there are a lot of developers who have these projects going on, like Thane especially has a lot of group housings.
I agree with you. See, first point that you do not require permission of 2/3 of customers of earlier registered agreements. So their consent is not required for any change now because they are under MOFA. Hereafter you will have different phase. So when you register now, probably if I am at your place, I will register one document. However, when I am registering with authority is asking me, is it an ongoing project and what are the agreements and commitment I have done under MOFA with the earlier customers. Suppose you have earlier customers, you have promised that the clubhouse will be ready by December 2017, your commitment stands under MOFA. Now you cannot say, of course there is one clause, but now you cannot say to MOFA guys that I am not going to give you. You have a provision of revising the completion date by one clause. But it doesn't mean that you are absolved of all the responsibilities. अभी तो मैंने नया डेट दिया हुआ है, पहला डेट का कोई लेन देन नहीं है. It's not so. So you can talk to me little later because publicly I cannot tell you what you should do.
Sir,
Some senior people are sitting here.
sir, माझा क्वेश्चन SRS स्कीम साठी आहे.
Please stand up, please stand up.
SRS स्कीम साठी आहे. ज्यावेळी SR या रेराला लागू आहे का? दुसरं क्वेश्चन असा आहे, SRA मध्ये लागू असेल तर एस्टिमेट कॉस्ट कुठली पकडायची, लँड कॉस्ट का रिहॅब बिल्डिंगची कन्स्ट्रक्शन कॉस्ट पकडायची एस्टिमेट कॉस्टमध्ये? कारण लँड कॉस्ट नसते SRS स्कीम.
रूल्समध्ये अगदी क्लिअरली लिहिलेलं आहे की जेव्हा तुम्ही रिडेव्हलपमेंट करता किंवा जेव्हा तुम्ही अकोमोडेशन देता एक्झिस्टिंग स्लम डेव्हलपर्सला किंवा त्या लोकांना, ऑल दॅट इज इन्क्लुडेड टू लँड कॉस्ट. कारण आपण तो खर्च केल्यानंतर त्यांना अकोमोडेशन दिल्यानंतरच आपल्याला जागा मिळते आणि FSI मिळते ना. सो इट इज व्हेरी क्लिअरली मेन्शन दॅट इज अ लँड कॉस्ट. So when you fill up a form, you have to be very careful in putting what is your land cost and what is going to be your proposed construction cost.
Clearly mention rehab building construction cost.
Sorry?
म्हणजे क्लिअरली construction cost लिहायची का rehab buildingची?
त्याच्यामध्ये रूलमध्ये क्लिअरली तुमची केस एक्सप्लेन केलेली आहे. एक प्रोव्हिजो टाकलेला आहे, त्या प्रोव्हिजोमध्ये लिहिलेलं आहे, असं लँड कॉस्टच्या प्रोव्हिजोमध्ये इन्क्लूड केलेलं आहे. हां, मी एक बोललो नाही साहेबांनी. एक ASR, आता एक फार महत्त्वाचा मुद्दा मी नाही सांगितला कारण सॉरी आय डिडंट टेल यू अबाउट व्हेरी इम्पॉर्टंट इश्यू. सर इज सेइंग दॅट इलॅबोरेट दॅट पॉइंट. Hereafter there will not be any time for answers, so I'll elaborate this point. Let's say that I have an ongoing project of 100 flats. I sold 40 flats, 60 flats are yet to be sold. Say, out of that 40 flats, I haven't yet collected full money. So this is a situation as on 1st of May. What rule mentions that for those 40 flats which are sold under MOFA, there is some balance payment which is supposed to come. So the chartered accountant will give certificate of those balance payment of 40 flats. That's number one. Number two, 60 flats are not yet sold. So as per ASR rate of 2017, whatever I am selling is different. As per ASR rate, government, you have to calculate how much is receivable for the unsold flats. The total of balance money for 40 flats and the new money for 60 flats, if this total is more than your estimated construction cost of the balance work, then you fall under 70% of the money going, further money going into that account. If this money is less to complete your project, then incoming flow of that 40 flat, 100% will go into that account. Now, there are experts here, whether it is as per law, how can rule change that 70% to 100%, I do not know. But this is what is written in the rule. And it is for the benefit that we developers don't run away with that fund. We have enough funds on site to complete the balance work. This is the idea. Are you clear? It took me some time to understand this, but you are intelligent people, so you understood fast.
Thank you.
Sorry?
Just let us understand this once again. Can you explain once again?
No, I'll repeat again.
Yeah, repeat again, please.
That's why I mentioned very slowly, because these things I understand. I'm not expert financial guy. I told you I'm side man, so it takes time. Let me tell you same example. 100 flat scheme is ongoing scheme now. 40 flats are sold under MOFA. I am a genuine developer. I'm working on site. That 40 flat 100% payment has not come because I have not completed the scheme. So on the day of registration, chartered accountant will give certificate of how much is the balance receivable from that 40 flat. It's simple, agreement is signed, some amount has come, so very simple to do it. 60 flats are unsold as on date of registration. For those 60 flats, ASR rate is known. So based on ASR rate, what may be receivable will be calculated. These two figures will be added. Let's say that these two figures totally 63 crore rupees total. And if my estimated cost to complete, there is a format given in the rule, estimated cost to complete hereafter. For ongoing project, hereafter also comes. For new project, estimated cost for the entire project. So estimated cost as on now, if it is more than this receivable, I am safe. Sorry, ulta. So if estimated construction cost is more, then the balance of all those 40 flats, 100% I have to deposit in their account. Okay, so it's simple, they want to see. Now there are arguments कि मेरा तो flat ready reckoner से ज़्यादा में बिकता है, तो मेरा वो rate लेना चाहिए. All that is over now. We have done all this. So government did not accept it. ASR is the rate.
Yes, thank you so much, ladies and gentlemen. Just last 3 questions for the day, and we have 3 people with the mic as well. And starting, we are getting a chance. Just a minute. We'll be starting from the front. Just 3 last questions and 3 people with the mic. Starting with sir in the front, please.
Hello. If we give disclosures, which are subjective one, then and the possession is also subjective to those disclosures, will the project be get registered under RERA? Will authority register those projects? I am repeating, sir. Suppose I am not sure about my cost today, for an example, because the finance cost is a factor which cannot be worked out today. It will depend upon the sale velocity and collection. So there is an uncertain number. Or I am not sure when my approvals may come, all the balance approvals. So the date of possession I am not able to commit. And we have to register under RERA. How that will be done?
This can't be done.
Can't be done. So what will happen to that project?
No, you have to give completion date with your own experience. You are expert developer in Thane.
Yeah, but
so
if
you must know what's
give
happening.
some disclosures. See, in SEBI it was happening earlier.
Chetan bhai, this provision is not there.
Is not there.
But I can tell you unofficially, don't quote me hereafter,
Yeah.
that if there is a genuine difficulty in completion, authority will look at your intention. And if you are not diverted funds, let's say that cement price instead of this present goes to 500 and 600 rupees. What developer can do? But if there is a genuine difficulty like this, like some few years back, entire labor force was not here working. So this situation, I'm sure government will have to think that I am not genuinely I am working on me, but this will come in the hearing and appeal and everything.
Okay, second question. Because we are all talking about ASR as a revenue to be counted. So there is all likelihood that the overall cost of the project may be more than 70% of ASR estimated revenue. It does mean then 30% will not be allowed to be withdrawn.
Yes. This is a formula given by government that ASR, there is a description as to how the money will come.
Yeah, it means very clearly, we all feel that 30% will be withdrawable, which may not be the case in most of the cases.
Sure, it can happen. If you have taken more funds from people,
I'm not saying that, sir. I'm saying my project cost is 100. My revenue estimate is say 140. So whatever money comes, I can withdraw 30%. And 70% goes to escrow. But as per the revenue estimate, as per ASR, is say 110. Then I will not be permitted to withdraw 30%.
True,
right?
true.
It means though all of us feel.
This is not mentioned in the rules.
Yeah,
that
it's not mentioned.
I mean, don't go and tell people.
Yeah. Sorry?
See, if you give ideas like this, government
we'll not
don't take
give
30% also.
I know.
So
that's my fear.
Yeah, sure.
Very great fear that all we feel that we'll get 30% out seems difficult, sir.
There is no provision like this, but you never know. In rules, government can modify rules.
They can, sir.
If they find
Yeah, they
after
can.
filling up the form that no, this project cannot be
yeah,
completed, the government has a responsibility to see to it that the purchaser gets his product properly. So they might come out and give instruction to you.
Yeah.
See, there is a provision that authority can give some instructions to me as to what to follow. It's not in rules, it's not in act, it's not in
Still
regulation.
they can.
But this
Yeah.
can happen. This
So
is
we
a
all
new-
developer has
This is a
to
new
be-
example you are giving.
We all developer will have to keep this in mind. I am saying, sir, because otherwise it is predefined that your net profit, because it is post your expenditure and post your finance cost, it is your predefining your net profitability as 30%. No developer works on 30% net profit, sir.
Chetan bhai,
Yeah.
if you recollect, and Jayesh bhai, before you came, I just mentioned to my friends, estimated construction costs and balance estimated construction cost for the ongoing project, these are most important things for my life now, hereafter. If I make a blunder there, mistake there, I'm gone. On the day one of registration, I'm gone.
Gone.
So that's why 2-3 times I mentioned this figure, estimated construction cost. Please be careful so that your project is known to you day one, everything is known, specification is known. बाद में कुछ नहीं चलेगा, वो टाइल मिला ही नहीं, मैंने ऑर्डर किया था, वो सीमेंट बैग, nothing will work. Otherwise, what Chetan bhai is saying, that will happen. The 30% also will not be able to withdraw. Nowhere in the act and rule mentioned how I have to use 30%. Today freedom is there, but Chetan bhai is saying that that freedom may be restricted also.
I
in
don't
case
think
authority
it is
feels
there,
that
sir.
I am unable to complete the project.
But I sincerely don't feel it to be there, sir. I mean,
It's not
the
there.
finance guy can reply on
There is
this.
no mention of 30% how to use.
No, I'm not saying that. I'm saying the total estimated cost may not permit us against ASR rate to enjoy this 30%. I mean, that's my point.
Ask Jayesh bhai later.
Yeah, Jayesh bhai can answer on this. I'll be happy, sir.
Thank
You're right. What you're saying is that 30% is not mentioned anywhere that what you can do it, but certainly 30% is free for you to use it. What it says, what is getting blocked is only 70%, right?
I may not be eligible to take that 30% out.
Right.
Because of estimated ASR rate.
Right.
Vis-a-vis my cost.
Right. No, that is true. That is true. That I'm agreeing. So therefore, possibly you may not be able to withdraw entire 30%, but yes, certainly not that entire 30% will get blocked, kind of.
70 government का है. But there is all probability the moment we start working on our estimated cost versus sir revenue estimate of ASR. Your rate can be higher than ASR. You may have that liberty, but government is not going to count on that. They are going to count on ASR, and I don't think, sir, any developer has a net profit of 30%. So that 30% may not become withdrawable, sir. I mean, that's my feel. We can discuss it later.
Yes.
Yeah.
Right. Thank you, sir. Thank you, sir.
If I have taken a lot of money from people earlier,
No, if I have taken all borrowings, sir. No, if I have taken all borrowings from banks, right, to complete the project. My finance cost is higher. Anyhow, sir, I am not taking it beyond.
Thank you so much,
It will
sir.
lead to
The
something
gentleman
else.
behind, the guy behind you, sir. We was waiting for a long time. Please go ahead. Just last two questions, please.
Hello.
See, I would like to tell something on this aspect. See, the object of Act is to provide a cap on that 70%. Object of Act is not to freeze that 30%. So object is only to create a situation, and that too to ensure a timely completion of the project and the utilization of that 70% only for that project.
You are right, sir, provided your cost is less than 70% of your estimated revenue.
So estimated revenue, you have to estimate at the first place. That
They
discretion
don't-
is given to you.
But
no?
they don't any time say the estimated revenue to be mentioned, sir. They are talking of estimated cost to be mentioned. And this is my disconnect. This is where the disconnect is, sir. They are not talking what is your profitability, what is your estimated revenue. They are talking only on your estimated cost. And vis-a-vis your ASR rate, your estimated cost to us will never be, I mean, that's the catch, sir. That's the catch. That's the catch, sir. So we all developer feel बाबा 30% तो आज अपने को मिलने वाला है. I doubt.
Good evening, sir.
नहीं मिलेगा.
In
So all developer has to keep that in mind, sir.
You depending upon your own case,
Yeah,
you have to see कि वो 30% भी मिलता है कि नहीं
हाँ,
मिलता
वो
है.
देखना पड़ेगा, sir. Yes.
Please, the gentleman behind, please.
Doesn't mean that you reduce the estimated construction
No,
cost.
don't do that. Then we are
We are
gone.
not saying that you reduce that so
No.
that you get that 30%.
No, then you
You'll
are
be in a
gone.
bigger, you'll be in a bigger trap.
Yeah, bigger trap हो जाएगा.
Yes, please go ahead.
Okay.
Good evening, sir. My
Can I
question
tell
is
him the trap? Can I tell him the trap? Very important, sir.
Please.
Sir, the customer will go back to you that you spent less cost. It means you used lower specification than declaration, or you have to use lower engineering technology than declared, because your cost estimate is wrong. Material prices have not gone down, and your cost has gone down, is the trap. The consumer may take you to court that you have done substandard construction. Nobody understands construction. Nobody. I mean, after 50 years of your work or 40 years of my work, we are still learning construction, sir. We are still learning construction. So that's the catch.
So, but eventually the construction cost can go higher than the projected construction cost.
No problem.
So then how?
If it goes higher, no problem. But the moment it goes lower, you should. It's a problem for us, my dear.
We can say we estimate.
Sir, he will say you subsidize your cost to get 30% out of the system. And somebody can catch you us on
So we will only project that I assumed a lower cost and eventually I spent a higher cost. So then the...
Sir, your specs are known, your amenities are known, your consumptions are known, your engineering cost is known. How can you suddenly come and say, my cost has gone up? Sir, marginally is fine. 2, 3, 5% is fine, right? Your estimate has to be maybe, sir, plus minus 2, 2.5, 3%, but not 20%. Yeah? Okay.
Please, the gentleman at the back, please.
Good evening, sir. My question is regarding certain buildings where we have maybe a 2-wing building, a 5-wing building, or 7-wing building, where we have not actually loaded the TDR. We go in for IOD on basic FSI, and then as a second phase we may add staircase premium, and then we add TDR. So my building is planned with full FSI, but at present I have got maybe IOD at certain stage. I plan to take the second IOD after loading staircase premium, and maybe a third one when I do my TDR. Now the question rises registration and advertising. In registration, can I have it as phase 1, wing 1, 20 floor, wing 2, 6 floor, wing 4, 5 floor, wing 4, 3 floor. Second question, in that case, if my sales people are asking for brochures, I cannot show a wing with half proposed building and half proper. My planned building is full as per my FSI. It's a question of whether I am investing in the TDR at this stage or at a later stage. In that, how to go about registration and how to go about the marketing sales requirement where they ask, so that we don't fault somewhere. And the second small question, when we are giving the sale plans, as you said, the mock-up flat, they will see the curtains are there. In the sale plans, we put up a lot of furniture and all things in the sale plans.
What I understood from your question in short is that, and you correct me if I am wrong, that you have a project that you may use FSI first, then TDR, then paid up FSI. So on the day one, I do not have approved plans. Let me elaborate this, if that is the question.
No, I don't have approved plan to the full extent. I have approved plan.
Naturally, nobody has. Nobody has on the day one. This is what was mentioned in the Central Act. And this is where the government of Maharashtra gave us concession. Concession is in what form? That in the agreement you mention that I am going to use FSI of 5. It may not come, but you can decide what even future, whatever FSI I want to 5. Today I have got FSI of, in Thane we have at present 1. So I have FSI 1 plan. Thereafter I am going to have paid FSI of this much. Thereafter I am going to have TDR of this much. Okay. You can sell only what is approved. Okay. So if your FSI plan is there and it is approved, only that much you can sell. You can disclose everything. But if you have disclosed everything, later on when the plans for the further area comes up, you don't have to get 2/3 permission. that permission is deemed to have been taken already because you have disclosed all that. This is provided. There is a one proviso which is not correct in the rules. I have no authority to say that, but in one single building, you can have phases. This is what was written. So I also mentioned in one forum that you can have one single building in phases. However, it will not work out because the conveyance of each phase cannot be given. Say I have a 60-story building, and I thought earlier that it's mentioned in the rule that 20-story of FSI one phase, paid FSI another phase, and TDR another phase. It will not work out. So that is, there is a very wrong mention there. So single building must be having one phase. I'll repeat for your benefit. If you are disclosed properly, don't have to worry even if approval for the entire thing is not obtained.
And the advertising or whatever the...
You can advertise what is mentioned. Yes, you can.
As planned.
You can.
And a small one, for the sale plans, when we give floor plans, there if we show some furniture, is it alright, or now the floor plans will be blank, like a 2D colored plan, which even any architect will do, and 3D people are out of business?
You take a call on this.
So your opinion?
I don't know.
Yes, to the gentleman ahead, please, quickly come on.
I'm really scared of the brochure drawings now, brochures, and the films which we show, and the videos which we show, and the hoarding which we have, and we are in dream sometime. So if you can sell your dream properly, go ahead, take your own risks. I would not recommend that.
So my question is regarding...
See, you sell your product. There is no point in showing Mercedes car next to your flat, as I told you, and this garden. I saw in Gauthan area, some place in, let me mention the city, Kolhapur. He has shown nice scenery behind that building, and the building is standing in Gauthan. But he can sue you that you gave a wrong impression. These cases will come over a period of time. You will get educated. उसने ऐसा नहीं किया, करना नहीं चाहिए था, तो I will not do. All that will happen over a period of time.
Yes, please, just the last question.
So my question is regarding formation of society after 51% booking done. Sir, how without OC the society formation will happen? Without OC, the formation of society is not allowed. Suppose I've just started the project and my 51% booking is
No, that's not the case. Formation of society is allowed. On booking of 51% purchasers, allottees once book 51%, you are under obligation to form society. So formation of society has nothing to do with the obtainment of OC.
What if the customer from 51% starts cancelling? What is the status of that customer? How do I treat them?
No provision in RERA.
Thank you so much. Ladies and gentlemen, okay, just one quick question, very quick question. The last question, please.
This is not a question. His question. Before, at the time of the registration, I am a chartered accountant representing Cosmos Group. At the time of registration, only the CA has to give a certificate regarding the estimated revenue. And at that moment only, if it is, it's a not 30% auto withdrawal. It's not 30% auto withdrawal. So it's not a 30% auto withdrawal for ongoing projects. It's first, once you give it for the RERA registration, you give your estimated revenue collection against your estimated cost of construction. And then, if you're crossing your limit, then only you can do the auto withdrawal of the specified percentage certified by the chartered accountant. And to be, every time if you're withdrawing, you will be requiring 3 certificates, architect, engineering, and the CA certificate. Quarterly certificates, and then that CA has to be separate from your statutory auditor. So every year you have to get a statutory auditor certificate separately, which will in turn tally all the withdrawal certificates. And you will have to submit a copy of those certificates to the bank also for the purpose of the withdrawal. The bank will not allow you to withdraw the money till the time all the certificates are not there.
Thank you so much, sir. This brings us to the end of our second session. एक बार जोरदार तालियां for both of our panelists over here. Friends, please note down your questions. We'll try and have a second session of question answer as well in the end. Right now, Merchant sir has a commitment he has with you. Thank you so much, sir. Thank you so much for being over here and sharing your perspective on RERA. I request, sir, please be over here. I request our president, Sri Ajay Asher, along with our past presidents, Mr. Mukesh Savla, Mr. Chaitanya Parekh, and Mr. Sailesh Puranik, to please come on the stage and felicitate this champion, because he has enlightened us on this subject, this complicated subject of RERA. I request all our presidents to please come ahead and felicitate Mr. Merchant. दोस्तों एक बार जोरदार तालियां मर्चेंट सर के लिए. And also we would like to felicitate our second speaker, Mr. Sanjay Borkar, I'm really sorry, Mr. Sanjay Borkar. I would like to felicitate our second speaker and legal expert, a legal veteran as we say from Thane, Mr. Sanjay Borkar. Chetan Uncle, please. Yes. Ladies and gentlemen, we would like to quickly start. Ladies and gentlemen, we would like to quickly start with our third session. We call it the legal perspective. And again, we have heard him very recently, and now we will throw his perspective on this very subject. I would like to invite Mr. Sanjay Borkar sir on the stage. Advocate Sanjay Borkar, a veteran of legal mind of Thane. Sir, please, the stage is all yours. Please come ahead. दोस्तों एक बार जोरदार तालियां से इनका स्वागत करते हैं हम लोग. Thank you.
It will not be proper if I address you without any book and without the brief, because lawyers are basically known by the briefs and by the books. And what I am expected to tell you about RERA is the legal implication of RERA on the real estate sector. So therefore the need of book is required. Now I could not get an occasion to listen to the speech of Merchant sir in totality, but I am sure that the way in which he was presenting most of the aspect of RERA, practical aspect of RERA, financial aspect of RERA, and the impact on the real estate sector of RERA is almost covered by him. What now I am supposed to cover, what I perceive is that the legal aspect of the RERA, legal implications, and what are the provisions regarding contravention of RERA, the authorities to whom the powers are conferred to take action, and what are the consequences in case of breach if committed by the developers. Now the entire gathering is of the developers, and therefore I will focus my speech from the perception of the developers. Now RERA, as we understand, has virtually started a new era in the real estate sector. Previously we were governed by the old enactment of 1963, that is Maharashtra Ownership of Flat Act, and then for 50 long years this sector has been covered by this particular enactment. It was also called as a beneficial enactment for the benefit of the flat purchasers, and legislature probably thought that this is not giving the required benefit to the customers, and therefore they thought to amend it. Now it was initially a Maharashtra Property Act 2012 which was introduced in 2012, but then in real sense it could not be implemented, and now in 2016 RERA has came into effect. Now the first aspect which is very important to be noted is that now we have a uniform enactment for the entire country in the form of RERA. Initially there were the state enactments which were governing the public real estate sector in each of the state. For us it was the Maharashtra Ownership of Flat Act. Now RERA is the central enactment, so there is a uniformity in the entire country vis-a-vis this public the real estate sector is concerned. No doubt, power is given to the state government to frame the rules, but ultimately rules will be for the aid of main act and for implementation of the act. So rules may change, but the overall object is same for the entire country. Now, as is shown, RERA has introduced so many vast changes. Something absolutely new has been pointed out, has been placed before us. So naturally, the first human tendency is that we tend to resist the change. We don't like the change because we are habituated to something which has been followed for 50 years, and suddenly after 50 years, if we are subjected to something new, we probably may not like that. But my request to all of you as a professional is that there are so many advantages of RERA, and as a developer, you will ultimately welcome RERA if you understand the real object of the enactment. The real object of the enactment is absolutely very clear and twofold. Firstly, to have absolute transparency in the sale of a premises and the relationship between the developer and the purchaser. Secondly, to have absolute discipline in this real estate sector. And the consequence of discipline and transparency will be a professionalism and a development. So the entire object is revolving upon this. Discipline has been brought by this enactment and transparency is introduced. So you cannot be now, you cannot think of not having any transparency. I will give you only one example. A area, carpet area of a flat. Now, I am an advocate for the developer, and eventually I am a purchaser also of one or the other flats. So I have a threefold experience as an advocate, as an advocate of a developer, and as a purchaser. Now I am just talking from the perception of a purchaser. Whenever a purchaser approaches any developer to any project, then they are given one brochure, they are given one pamphlet, wherein or they come across an advertisement where it is shown or it is advertised that we are selling a flat at the rate of rupees say 6,999. Now this 999 is a very popular concept among the developers. So 699 is the rate at which we are selling the flat, and then law contemplates, agreement contemplates that flat is to be sold on the basis of carpet area. Even that was the situation when the MOPA was prevailing, and previously also you were supposed to sell flats only on carpet area. So the carpet area in the agreement written is different, and what is a brochure which is circulated or what is the pamphlet which is circulated gives a rate on the basis of saleable area. I am sure that this was the practice adopted by almost all the builders. So rate is given of a saleable area, it may be 7,999, and agreement says carpet area, and if I calculate the rate, ultimately the rate goes to 16,000, 17,000, 15,000, whatever may be. So what has been what has been done by RERA is that they have defined the carpet area. Now that carpet area is absolutely defined, there is no ambiguity. Carpet area, suppose we have to construe the carpet area of this hall, then carpet area will be calculated from the outer wall. This internal everything will be inclusive of carpet area. If there is an internal wall, even that is included in the definition of carpet area. And what is excluded is the balcony, veranda, exclusive balcony, exclusive veranda and exclusive terrace. Now this carpet area as defined in RERA may not match with the carpet area as is given in the DC rules and regulations. Every planning authority will have its different DC rules, and therefore they may have different meaning assigned to that word carpet area. But then there is a provision under RERA of having overriding effect of RERA to any other law which is prevailing in India. So by virtue of that, this definition given in RERA of carpet area will prevail upon. Now there is embargo created under the Act that you cannot sell on the basis of anything else than the carpet area. So what you are supposed to sell is a carpet area, what you are supposed to advertise is a carpet area, and therefore cumulative reading of the entire act will make it absolutely clear that even in the advertisement you are precluded, you are prohibited from putting the rate on the basis of saleable area. So that saleable area concept has gone. You cannot adopt that concept if we read the provisions of RERA. Now this is the major change which is introduced by way of RERA, because this will naturally affect your financial calculations, for which another speaker will enlighten you on that aspect. So far as the legal aspect is concerned, a uniformity is now brought vis-a-vis the agreement, definition of carpet area, disclosure to be made to the regulatory board, and disclosure to be made by way of advertisement. Now the whole concept of RERA is to bring uniformity about your disclosure. So what it talks about a disclosure? There are 4 types of disclosure. First disclosure is by way of registration with the authority under section 3, where you are supposed to disclose all and everything, almost everything about your project, including the proposed development. Now the questions were asked as to if my plan is sanctioned today and if I am registered only my sanction plan, what about my future development? There is no ambiguity at all. If we read the provisions of section 3(4), which contemplates what is the disclosure, then disclosure is that suppose today I am undertaking a development of 4 acres of land, and in that 4 acres of land I am contemplating 3 phases. First phase I am contemplating 2 buildings, then on second phase 2 buildings, third phase will comprise of 3 buildings. So there will be total 7 buildings, and today I am registering only first phase. Then what I am supposed to do? I have to disclose the proposed development also. What is the intention of RERA is that you should make aware the purchaser who comes to you for the purchase of flat, what will be the total scheme, be it a sanction scheme today, be it maybe a proposed scheme. So that first disclosure in almost totality has to be made at the time of registration. Now that is an online registration. A website is created, and on that website your entire details will become available to the public at large. So that is the first public disclosure. Second disclosure will come by way of advertisement, prospectus, social media, digital advertisement, and all that. Third disclosure will come by way of agreement for sale, which you will enter into with the flat purchaser, and even before that one stage is contemplated under RERA of execution of allotment letter. Even while allotting the flat by way of allotment letter, you are supposed to make all disclosure. The endeavor is made to ensure that there will not be any inconsistency or contradiction in that disclosure. That is the main motto of RERA. If you follow that, you will never land in trouble. First thing. Second endeavor is that there has to be total transparency. Now how that total transparency will be assured? That total transparency will be assured only by way of this consistent disclosure. If the disclosure is absolutely correct, if disclosure does not contain any misleading or false information, then there will be total transparency between the promoter and between the developer. Third thing is that, which is tried to be assured, is a date of possession. The whole endeavor of enactment is to give solace to the purchaser of a thing, that when I approach a developer, I must be sure about 3 things. What is going to come, and there should not be any misleading information about that. Secondly, what would be my exact carpet area, and thirdly, what is the date of delivery of possession. Inter alia, to achieve all these 3 objects, the entire enactment has been made. So even though it appears to be very complicated in nature at first place, it is not. Procedural part you may feel complicated at this juncture. For example, merchant sir has told you that we require a separate session of 3 hours probably to understand how to fill the form. Yes, he is right, because filling the form at the first instance may be a bit difficult because it is something new to us. But then that is a procedural part. what as a developer you have to conceive in your mind that you are not supposed to make any false assurances, false declaration and misleading information. If that you adhere to, if you don't make any commit any mistake on this aspect, you will never land in trouble. Now, after ensuring all these things, there is a comfort zone created for the developers also. For example, under MOFA, there was no provision contemplating any punishment to the allottee. Allottee was absolutely scot-free. If RERA contemplates penalty even on a defaulted allottee, that penalty is such that which will go to the extent of even 5% of the cost of that particular flat. So a balance is strike in the provisions. It is not that only some obligations are created on the developer, but obligations are created even on allottee. Even a punishment is contemplated against the allottee if he commit default in the compliance of orders by the regulatory authority. So this is the second aspect. A balance has been struck regarding the obligation of the allottee also. So builder will also get a solace that if I select a particular person as a allottee, then there has to be assurance from the allottee also about the payment, and if we don't pay, what is the exit route, what is the way out, and how I can recover that amount, and what will be the consequences arising out of that. All provisions in that regard are made in a very balanced way. There is no discrimination as such sort that builders are discriminated and unfavorable benefits are given to allottee. That is not the case. Third, the most important aspect is the exclusion of jurisdiction of civil code. Under section 79 of RERA, a specific provision is made whereby civil court's jurisdiction to decide any dispute between the developer and the purchaser is taken away. Now, as a litigating lawyer, it is my own experience that even though we read in the newspapers or in social media that lot of malpractices have been committed by the developers, or that developers commit some wrong vis-a-vis the purchaser, but my experience as a litigating lawyer is little bit different. I have come across so many litigations where by way of construing or rather misconstruing the provisions of MOFA, purchasers have filed thousands of blackmailing litigation. I am sure that most of you must have come across of such blackmailing litigation in the form of suit under section 7 and 7A of MOFA, suit under section 4, suit under section 10 and 11 of MOFA, and the criminal complaints under section 13 of MOFA. I have seen so many builders unnecessarily who were required to face a criminal trial under the provisions of section 13, where purchasers, after taking the possession of the flat, after enjoying all the benefits, have started a blackmailing practice of filing a false criminal complaint, maybe after even 5 years, 10 years, 15 years, because there is no limitation prescribed for taking that offense, even though that is there in the criminal procedure code. So that particular blackmailing litigation at the hands of purchaser will be stopped forever, because section 13 will not come into effect now. You can't go to the civil court for any litigation, and only one and single authority is established for the redressal of grievances of the developer as well as of the allottee. So it is not that the forum is created only for the allottees, but a forum in the form of regulatory board is created for the benefit of the developers also. If we look the provisions of law, there is a provision whereby in case of any breach or contravention, maybe by the developer, maybe by the allottee, only authority before whom one can go is a regulatory authority. So there is like one single window system which you all are expecting so far as approvals are concerned. For the approvals, you are still not getting that single window system. But so far as your grievances or redressal of your grievances is concerned, RERA has made a provision of single window system. Now, it has a very long repercussion. I have observed that there had been variety of litigation under MOFA. Under MOFA, you could have gone before the consumer code, before the civil code, before the competent authority established under section 7 subclause 2, before the high court, before the state forum. So many authorities, so many ways made available to the purchasers to redress their grievances. That has been corrupt. Now only regulatory authority who will take cognizance of your grievances as a developer or the grievances of the allottee as a allottee. Now a scope of grievances is also very limited. Initially under MOFA there was lot of grey area. For example, initially there was a provision of section 7 which was prohibiting any additions or alteration in the structure of a building by the developer once the flat is agreed to be sold to the purchaser. Then 7A was introduced and 7 was clarified, and then it was made clear that for the layout development such consent is not required. But I am sure that you must all have come across numerous litigation under section 7 and 7A because of grey area and because of variety of judgments of High Court and Supreme Court. Ultimately a chaos has been created. There is no clarity as of today also. I had come across a latest judgment in which just for the sake of example I am giving you how builders have been exploited by the flat purchaser. Out of 700 flat purchaser, one flat purchaser filed a litigation inter alia seeking an injunction under section 7 saying that 15 buildings are constructed and the construction of this 16th building may kindly be stopped because this was not disclosed to me. He lost in the lower court. He lost in the appellate court on merits, and High Court in the second appeal has entertained him and putting a question to the builder asking that how can you construct this 16th building if it was not forming part of your layout which was earlier disclosed to them, and based on that the definition of section 7 or provision of section 7 is sought to be now enlarged, and I apprehend that there may be a judgment against the builder after even winning at 2 stages. So this all used to happen in respect of MOFA because there was ambiguity, there was no clarity about the provision regarding the disclosure. Now that ambiguity has been absolutely cleared by virtue of RERA. So if there is no ambiguity, there is very little scope for anybody to go to any authority and make any complaint. What is your obligation as a developer? If you fulfill that obligation, I believe that there will not be a single complaint against you. Only problem or only difficulty which you may face as of today in a gestation period, because it is newly introduced. Only 1st May was the introduction day and we are on the 4th May. So it is hardly impossible for anybody to have total grasping of the rules and the law and to enlighten everybody. It will be a learning process for all of us. We have to be united for that. We have to teach each other. We have to learn from each other so that we will be able to understand the procedural part. I am highlighting the word procedural part because procedural part may be little difficult as was explained by Merchant sir, but so far as legal aspect is concerned, there is no confusion. There is no threat to the developers. You need not worry about any litigation, because if at all there would be any complaint, the scope of complaint is limited, and that is only if you made any false representation. If you commit delay in handing over the possession in spite of there being no reasonable ground, then only there will be a complaint. Now that complaint scope is also limited. What is contemplated? A complaint has to be made to a regulatory board. An obligation is created upon the regulatory board to dispose of that complaint within a period of 60 days. And if disposal is not possible within 60 days, then he has to put a reason as to why that disposal cannot be done in 60 days. So a speedy disposal is contemplated. Appeal is provided to the appellate tribunal. If you feel aggrieved by that order, you can go in appeal within 60 days, and even appeal is contemplated to be disposed of within 60 days. So the time which the developer used to waste in the litigation in the civil courts, criminal courts, consumer courts is now arrested. Now no doubt there is a latitude given to the flat purchasers even to approach the consumer court, but I am sure that nobody will go to the consumer court. If I am a purchaser and if I am given a choice to go before a forum, by virtue of introduction of RERA, I will go to the regulatory authority only because speedy disposal is contemplated. It is beneficial to both. Whether there is a substance in the complaint or not is a different matter, but at least you get a disposal. Ladders of appeal are very limited. One complaint to regulatory authority or adjudication officer under section 71, and then first appeal. That is the end of the road. There is no second appeal, there is no third appeal. Now High Court being a supervisory jurisdiction, ultimately you can go to the High Court. That apart. But then ladders of litigations are curbed, are reduced. Time is arrested. So there will be speedy disposal of the complaint. More important aspect is that what is contemplated is a penalty. No doubt a provision of imprisonment for 3 years is made, but the endeavor is made that that will be utilized as a last resort and not a weapon to create a threat in the mind of developer. That is not the endeavor, that is not the object of the provision. Object is very clear that do the things speedily, do the things as assured, and if you won't do, you will be subjected to a penalty which may go up to 10% of the total project cost. So a threat is created on the head of developer by way of imposition of penalty, and even if that penalty is not paid, then regulatory authority can go to the JMFC or the Metropolitan Magistrate and request him to take cognizance of the offence, and then there is a punishment by way of imprisonment.